Ma'am, we can start with the session. So, shall we begin now?
Yeah, I think so. Thank you.
A very good afternoon to one and all. I, Sanjana, on behalf of Faculty of Law, University of Delhi, in association with National Legal Service Authority, Supreme Court of India, welcome you all to a conclave on Indianization of legal system and education to commemorate the centenary year of University of Delhi. We extend our deepest gratitude to all our dignitaries for taking out time from the busy schedule. We are honored to have with us for the session, Chair of Session, Honorable Mr. Justice Sunil Ambani, former Chief Justice, Rajasthan High Court, our guest of honor, Dr. Pinky Anand, Senior Advocate and former Additional Solicitor General of India, and Dr. Rajiv Mani, Additional Secretary, Department of Legal Affairs, Government of India, and special guest, Dr. G.R. Raghavinder, Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India. We also have with us Professor Dr. Alka Chawla, Professor in charge, Campus Law Center, Faculty of Law, University of Delhi, and Professor Dr. Mahavir Singh Kalo, Professor in charge, Law Center 2, Faculty of Law, University of Delhi. We shall now begin with our second session for the day, how to use technology in Indianization of legal system. Let me now invite Professor Dr. Mahavir Singh, Professor in charge of Law Center 2, to give the welcome address. Sir has a vast experience of more than 2 decades in teaching constitutional law, jurisprudence, and law and society. He has served as the chairman, Haryana Janhit Congress, visiting faculty at Center of Consortium for Educational Programs, subject expert for selection of judicial officers at the Bihar Public Service Commission are a few of his many notable achievements. Now I would request Sir to deliver welcome address.
Thank you. Thank you. Am I audible?
Yes,
okay.
Yes, sir.
Thank you. Thank you, sir. Good afternoon, all of you. On behalf of Faculty of Law, University of Delhi, and National Legal Service Authority, Supreme Court of India, I cordially welcome eminent members of our law fraternity to this prestigious conclave. Indianization of legal system and education is a very contemporary topic, and I am very pleased to be part of it. In this session, there shall be deliberation on the use of technology in Indianization of legal system, and we have amongst us array of distinguished scholars. First, I would like to heartfelt welcome Honorable Mr. Justice Sunil Ambani Ji, who is chair of the session today. He is former Chief Justice of Rajasthan High Court. He also served as a chairman, Allahabad High Court Mediation and Conciliation Center, High Court and State Mediation Monitoring Committee and Computerization Committee, High Court and State E-Court Steering Committee, and it's our honor to have him with us on this stage today. So again, I welcome you, sir, for joining us. Thank you. Next, we also have, Sri Harish Salveji was supposed to join us as co-chair, but I am informed by director of the conclave that he won't able to join because of his sudden illness. So I sincerely regret for any kind of inconvenience on behalf of the organizer. We have Dr. Pinky Anand and Dr. Rajiv Mani as our guest of honor. Dr. Pinky Anand is a senior advocate and former additional Solicitor General of India. She is recipient of the French National Order of Merit by the President of French Republic, directly at the level of officer. She has received several awards for excellence in law, including FICCI and Bharat Nirman. I feel proud to announce that she is alumnus of University of Delhi. She did her graduation from LSR and graduation LLB from Faculty of Law, University of Delhi. Here, I won't hesitate to mention she's first woman secretary of DUSU in 1979 and 80 and won the battle by huge margin of votes. I welcome you, madam, from the bottom of my heart. I also yes, here we are having Dr. Mani, Additional Secretary in the Department of Legal Affairs. Is the group head presently looking after advisory work of various ministries of the Government of India, including Ministry of Finance, Ministry of Corporate Affairs, etc. I welcome you, sir, in this conclave. I also welcome G.R. Raghavinder ji as our special guest, who is currently Joint Secretary in the Department of Justice, Ministry of Law and Justice. He is also Mission Director for the National Mission for Justice Delivery and Legal Reforms. He is driving policy reforms for improving enforcing contracts parameter under the ease of doing business and e-courts project. He will be joining us in a while. Now, our own very dearest professor, as quoted by Dr. Pinky Anand also, our professor, Dr. Alka Chawla ji, who is professor in charge of Campus Law Center, University of Delhi. She figured in the top 100 powerful women in the law list released by the World IP Forum in 2021 and 2017. She is recipient of the Teacher of the Year Award, Female, 2018, given by Indian National Bar Association. She has also authored 2 books on copyright law published by Macmillan and LexisNexis. I welcome you, ma'am, from the core of my heart. Thank you, all of you, for patience hearing. And again, I welcome all of you on this pious occasion, on this contemporary topic. And now over to Sajjan.
Sir, I would just like to inform that Dr. Raghavinder will be joining us shortly. In the meantime, I would like to invite our guest of honor, Dr. Rajiv Mani, sir, to kindly address our students.
Thank you, Sanjana. Respected chair of the session, Honorable Mr. Justice Sunni Lambawani, former Chief Justice, Rajasthan High Court. My esteemed senior colleague, Dr. Pinky Anand, Senior Advocate and former Additional Solicitor General of India. My colleague, Mr. G.R. Raghavendra, Joint Secretary, Department of Justice, Ministry of Law and Justice. Professor Dr. Mahavir Singh Kalon, Professor in Charge, Law Center 2, Faculty of Law. And Professor Dr. Alka Chawla, Professor in Charge, Campus Law Center, New Delhi. My greetings to all of you on this at this conclave, and thank you, the Delhi University, for giving me this opportunity of participating in this esteemed gathering of experienced persons. In fact, it is indeed a pleasure that I could come before you and speak on this very important topical subject of use of technology in Indianization. So this is something which, in fact, the government is also very seriously pursuing these days. And in fact, the Panch Prana, which the Honorable Prime Minister had addressed the nation from the ramparts of the Red Fort on the 15th of August this year, had a great linkage to the concept which we are discussing today. In fact, as we all know and we understand that what is the aim of law? The aim of law in our traditional sense is to have a righteous and a virtuous society, so that wherein the disputes are minimal, the people are satisfied to the greatest extent possible, and there is a voluntary adherence to the concept of laws as laid down by the sovereign. Now here, as we see over a period of time, that the law has undergone tremendous change from the ancient times, what it was and what it is in its present shape. And it is the dynamism of the whole process that when we were in the ancient times, the law was dictated by the Shrutis and later the Smritis, which were recorded by the Dharmshastrakars, who laid down various facets of law governing the role of an individual and his conduct in the society in different areas. Of course, it not only covered the individual, but also the king and the different modes of the administration of the kingdom by them, whether it is the Arthashastra by Kautilya or the various Smritis which are written by the great sages like Yagyaval, Kashyap and others, that they laid down a code of conduct for the society and the individuals, including the sovereign. Over a period of time, these, of course, had undergone change. And one problem which the society and over a period of time, which we are facing, in fact, now also when we have a look at those ancient texts, when we talk about Indianization of the Indian legal system, is that the ancient text actually had a concept of governance wherein the religion, the polity, the society, and the law all were actually a part of a uniform group, which governed, was a part of the text which these learned sages had actually laid down in their various smritis. So legal framework as such was not an isolated concept. It was a part of the subset of the overall governance aspect of the society by the sovereign and covering various aspects. So now in the modern times, when we speak about Indianization, and then naturally it is a corollary, we need to look to our ancient text for inspiration and what guidance they can provide. So at times it is felt that yes, the ancient text sometimes merge the concepts of morality, ethics, justice, and law and administration in their sayings. So of course, it requires a bit of detailed study so as to how we can actually differentiate between these concepts, because the law as per the ancient text is not something which is, it is derived from the temporal power. It is something which is divine in nature, which has been revealed to the sages, and throughout the ages, then it was through the Shruti that is passed from one generation to another. And of course, when it was codified in the form of Smritis, that what remains our knowledge for the present times. So it is actually the main goal being the promoting good conscience and the desire for establishment of dharma. So now the key word when we talk about the Indianization of the laws in the present context and in the Indian context is, of course, the understanding the word dharma. And as we all know that the word dharma is not a synonym of word religion. It is in fact righteous conduct. And that righteous conduct was there for everyone. As we all know that the present society, the modern constitutions and the Renaissance period and thereafter the French Revolution, the American Revolution and the other revolutions which took place all had the emphasis on the concept of rights, the liberty. Now the Indian text, when we go and have a look at them, it is all based on the concept of duty. So they thought that if one person is doing his duty diligently and sincerely, then it takes care of everyone's right. In fact, the right of one was to do his duty diligently. That was the concept which we had earlier. Now, in the present times, when the law has been codified to a great extent, we are a common law country. The codification process is the primary source of law. The constitution itself is the apex law of the country, and all the laws flow from it. The constitution itself is a gift from our founding fathers to the people of India, wherein now the sovereignty vests in the people of India. It is they who have actually drafted the constitution for themselves. So now, as we say, when we speak about Indianization, so at least we can say that all the laws which have been passed pursuant to the independence of the country and coming into the force of the constitution are laws, in fact, in Indian context and framed for Indian people. I do not speak about the pre-independence laws. They were, having a different connotation and context because they were a product of a colonial mindset. The laws had been framed by the colonial masters for the colonial servants. It had a different agenda, a different objective, and a different goal. But when we speak about the law in an independent India and now the need for Indianization of laws, what do we actually mean by it? To my understanding, we not only mean the legal framework, the legal thought, but the overall process of governance as to how the country governs itself. Law is a subset of governance. It also covers the various facets of administration, day-to-day administration, whether it is undertaken at the highest level of the government or at the ground level by the persons who are responsible for discharging their duties. So that is a subset of governance, that is the legal system. And then the legal system is complemented by the judicial processes. When a person approaches for any dispute and takes recourse to litigation or approaches the court for relief, what does he mean? He should understand the court processes in a simple language. He should understand the processes which are being followed so that he knows whether what he wants actually is being said before the court, the judge is appreciating it, and thereafter, of course, he will take decision as per law. What is correct in law, that decision would be taken. Now, there is a big gap in all these situations. We have made laws by the Indian Parliament, by the state assemblies, but the law system and the precedents which are being followed are those which we have inherited from our colonial masters. So the same language which were used by the Britishers before they left us, we are still continuing with it. However, the Britishers on their part, they have actually graduated, gone for simplification, while we have graduated more in the era of complexities and rigidities. There is a plethora of laws which are there in our country presently. And I think, in fact, we should also address that now the law is not mainly found in the substantive law, that is the principal legislation, but more in the subordinate legislation, that is the rules and the regulations. So sometimes I feel that now it is an era of regulatory despotism. We need to curb the large number of subordinate legislations which are very difficult to understand, because of course we know that the parliament and the state assemblies do not have the time and the energy to devote time for drafting of these rules and legislations, and that is why they are left to the discretion of the executive so that they can carry forward the objective of the act. But at times, in that guise of the formulation of the rules and regulations, some discrepancies do happen and some complexities creep in, which make the administration of the act very complex and very difficult for any person to understand. As we all know, the language of the courts in India, superior courts in India, is English. The drafting of the laws in our own union government is done in English, and then it is translated in Hindi. The thought process is in English. We follow the British precedents, and that is how the laws are being drafted. And the ideas which we want to convey in simple language at times are not reaching the masses through the system of codification of laws or the enactment of various legislations. This is something which I think we need to really look into it, because when we speak about Indianization, these are the 3 or 4 major challenges which we need to face. First of all, the use of simple language, the use of local language, the use of language in the courts, and the simplification of the judicial processes. As a layman, we all know that there are 3 institutions where a person would not like to enter willingly. That is the courts, that is the hospital, and that is the police station. The language which is used in the police station while lodging an FIR, if you go, the complainant cannot understand what is being written. The language is so complex, comprising of Urdu words, which at one time may have been very relevant for the persons to understand, those who were the ruling class, but at present times it is very difficult for a person to understand the the contents of the FIR which are being lodged, or the contents of the term which are used in revenue records. These are very complex terms for a modern educated person to understand, because there is a great disconnect between his process and the language which is being used. So the Indianization, concept of Indianization of laws which we are discussing about, and of course how the technology can augment it, can help in implementation, is twofold. First of all, as I mentioned, that we need to take reforms at the legislative reforms for simplification of laws and languages. Of course, for new laws, we have already initiated that, but a great plethora of laws which we have inherited. In fact, there are about 207 pre-independence laws which are still effective and still under implementation in our country. They have been passed when we were the colony of Britain. So there is a different, angle to that, those laws. The present laws which are being drafted, Ministry of Law and Justice, efforts are there so that they are in simple language. But as I mentioned to you, the court language is also English. Of course, about 4 or 5 high courts have already initiated the process of use of bilingual. That is, they can use Hindi in the case of Uttar Pradesh, Bihar, Madhya Pradesh, Rajasthan. And there are other proposals from other states also, so that the high courts can use the regional or the regional language and along with English. So that is something which we can, and now with the live streaming of cases, many high courts have started, and now the Honorable Supreme Court also has started live streaming the cases of the being referred to the constitution benches. So there is a great urge in the public to see these proceedings, to understand them. But complexity in language and the complexity in processes makes a disconnect. This is what we need to address. So first of all, while we need to look at our ancient texts, our ancient wisdom which is there, and there are plethora of laws which are there in the secular regime itself. They do not apply to any religion specific. They lay down the concepts which are actually applicable even today to a person of any religion. They are since secular law, and they cannot be classified as a law for belonging to any particular religion or any subsect of any religion. So in that manner, when we speak about Indianization of laws, the subject is quite vast. It is very subject of great relevance. In fact, in today's time, it requires a lot of discussion, debate among the various stakeholders, with the executive, with the judiciary, and of course the legislature, because these are all the 3 organs which are there in the formulation of any law. The executive initiates it, the parliament enacts it, and the judiciary interprets it. So the role of all the 3 organs of the state are equally important in the administration of laws. Now, when we come about the other processes, that is the judicial administration, that is also the sovereign function of the state. Traditionally, the concept of courts was not there in the ancient times, and the resolution was mainly done through the panchayats or the local councils or the shrainis in the commercial guilds of merchants who were dealing with a particular type of trade or commerce. In fact, today, in the present context, the government is greatly taking the step forward for reforms in the arbitration law, and various amendments have come from time to time in facilitating the easy resolution of commercial disputes through the alternative dispute resolution mechanisms, mainly arbitration. The second concept of ADR, that is mediation, is also very eagerly taken up by the government, and a bill in this regard is already there for the parliament, and hopefully by the winter session of this year, it may be enacted. That is a concept which is a very similar and very familiar with the Indian mindset. Because over a period of times, having been governed by the Britishers, all of our mindset actually and psyche has become court-centric. Whenever we have a dispute with any person, we always say that we will see you in court and we will meet in court. In fact, even young couples going for divorce, they have such bitterness in that they say that we will not talk to each other, we will not talk to any mediator, we will only see you in court. So this is the court-centric concept which has actually occupied our minds. We need to change it. We need to encourage the traditional, mode of resolutions, mediation, and that how can be done, because it is intrinsically linked to respect for elders, and elders not only in our family but elders in the society. So until and unless the whole subset of education, legal education, and the governance aspect merge together and see that the disputes can be contained through informal methods, And in case they are required to be brought before the courts can dispose them of within a easy, effective, and with minimum costs. That actually means the true concept of dharma in its interpretation in the modern times. That is, the persons who are entitled to perform their duties, they perform their duties. The persons who are entitled to enforce their rights, they enforce it with minimum inconvenience. These are the concerns we can undertake and which we should undertake. And now the second topic is regarding the use of technology. Use of technology, as we see, is a major factor. In fact, during the COVID times, as we all know, that the justice dispensation system, despite the lockdowns and the various measures to curb the movement of people which were necessary to contain the spread of COVID, the justice dispensation did not stop. And the courts functioned in the virtual mode. Persons joined the hearings, the advocates could join the hearing. Justice dispensation and decisions were as fast as could be possible with this aid of technology. Now, when this technology is already there, it has become a part of our system. In fact, the present session which we are having is also just a manifestation of that same technology. We have not seen each other in person, but we are meeting through virtually and able to understand each other's thoughts and each other's goals as to what we want to achieve through this conference. So these all technology is, of course, my other colleague would be dealing in great detail. But what we require now is that the goals, the Panch Pran, which the Honorable Prime Minister had mentioned during the ramparts of the Red Fort, that is, goal of developed India by 2047. We need not be a developing country anymore beyond 2047. We need to be a fully developed country. We need to be proud of our own institutions. How can we be proud of our institutions? Only when we are proud of our own language, our own culture, our own traditions. We need to remove all the traces of colonial mindset. In fact, the government has already, in the armed forces, there are many traditions which are based on the colonial legacy. They are also being changed and removed. Similarly, we take pride in our roots. This is what concept of Indianization is, and which is going to take place in this conclave in the field of legislation. Then we talk about our unity of goals, objectives, and unity amongst people. That is a concept which we need to promote, and that can take place when the law is applicable equally to everyone. There is no discrimination. So that is, in fact, unity is assisted by the concept of rule of law. Then this sense of duty amongst the citizens. That is something most important. And again, it links us to our own ancient traditions where everyone had, we have a duty-centric society. And when we used to perform our duties, all the rights of the people and the society were safeguarded. In fact, I have tried to, this is a very vast topic and we can speak and talk for hours on this, but given the constraints of time, I need to wind up. And now, before I wind up, I convey my thanks to the organizers and the learned professors of the Delhi University, led by the Vice Chancellor, Professor Dr. Yogesh Singh, the Dean of the Law Faculty, Professor Usha Tandon, the PIC in charge, Campus Law Center, Madam Professor Alka Chawla, and other team members of this conclave and organizing committee who have facilitated the happening of this conclave. In fact, I am also alumni of the Campus Law Center, so it's a great privilege and opportunity for me also to come amongst all of you and speak a few words amongst this esteemed and privileged and very experienced guests who are there. Thank you very much.
Thank you so much, sir. Your words were truly enriching and enlightening to us. I would like to now invite our guest of honor, Dr. Pinky Anand, to address the gathering.
Thank you, Sanjana. Good morning, good afternoon. It's kind of turned the clock around. Professor Kellon, the Honorable Chairman of the session, former Chief Justice Mr. Ambani, Dr. Mani, I have known for a considerable period of time, as I have known everybody else. Professor Alka Chawla, one of my dearest colleagues, and I don't know whether she's senior in terms of age, but she's definitely senior in terms of status. So good. It's really very fortunate of us and to see each other in this environment and to discuss certain critical issues which arise for consideration. Sanjana has been an excellent moderator and coordinated very happily also, and a very smiling face. So the best Indianization that I can think of in the current session is a couple of things that I think start off with Sanjana as the smiling face of the entire background. Dr. Mani has already actually given an extremely elucidative discourse on the subject, and I'm rather impressed. And I'm thinking about the various ramifications that he has put forward in various ways. The two things that I think this subject evokes in my mind, and incidentally, before I even commence there, I must again thank the Faculty of Law for having educated me and brought me to the position that I am. So one of the greatest Indianizations of the legal system is the Faculty of Law, which has produced stalwarts in all directions, including Dr. Rajiv Mani, who of course happily also mentioned regarding the faculty. And I might say that why I say that is Indianization incidentally is because it is a hands-on approach to the entire system of education and an overall development. So I think that facet of the Faculty of Law is itself a precursor to the concept of Indianization. And whoever is a good law student, obviously, will progress on to becoming a leader of the bar or leader of the judiciary. We've had several judges who are at the Supreme Court even now, large numbers which have represented the faculty. And I think that process is inculcated as a concept of how to proceed in life with an Indian outlook. And therefore, the greatest tribute to the faculty on the Indianization. The second interesting feature that I wanted to point out now is the fact that we are talking about Indianization, and happily, I, as a second generation, digital world generation, I might say, have actually been able to acclimatize myself to working on the digital platform. And if Harish had been here, he was one of the first to really start off very effectively with the digitalization of the entire concept of law and move with the entire systems. So while we on one hand talk about Indianization, one of our greatest features in Indianization is the fact of our adaptability and the way to look forward and the way to transform ourselves, the way to ingrain the best in the world as it is. We may go back to Swami Vivekananda also, so whether East goes to West and West goes to East. So while we talk about a concept of Indianization and we respect our greatest traditions that we have learned, and some of which, of course, Dr. Mani has been kind enough to elucidate, we do at the same time have this inert ability of Indians to further transform ourselves. And I think that has been manifested a lot in the Constitution. I think our Constitution, which came into being about 70 odd years back, has ultimately given us the complete weaponry, if I might say, or the complete platform to indeed transform ourselves and to adapt into ourselves, not only the colonial legacy removal, so to say, or the removal of colonial legacy, which has been there because of our history, but in fact to give ourselves the ability to transform the duty concept, the rights concept, the interplay between the two. And I think that is one of the most important features that Dr. Mani pointed out, which is also my theme song most of the time. We talk about rights, we need to go to duty. If we perform duty, the rights will automatically transform themselves. I might even go to J.S. Mill, for that matter, Oliver Holmes, Justice Oliver Holmes, to say my freedom ends where somebody else's freedom starts. These are the concept of public good versus private good. And I think dharma, as we know it in the Indianized concept, and some of which Dr. Mani again elaborated, is something which talks about public good. So we are here talking about Indianization as a concept of public good, as a concept of duty, as a concept of improving the lot of humanity. We have a population of about 141 crores today. The greatest tribute that we can give our society is to ensure, in terms of law and justice, that we can give justice to all. And we can give it in the easiest possible manner, the simplest possible manner. Access to justice and rule of law is one of the key principles of a democracy. And I think that is where the Indianization concept mixes and merges with the entire theme of this current subject today and the conclave today. I might go back to why we have come to this discussion on this platform, on this subject. And really speaking, that transforms itself from the fact that there are so many value systems that we are talking about. And today we are talking about new developments, we are talking about liberalization. But at the same time, I would title my subject as Back to Roots. So we go back to the roots from where we began. We see and analyze as to what our scriptures have given us in various different forms as far as law is concerned. The mandate of that, the value system of ethics, the value system of morality, the value system of public good, and to transform that into the concept of law, because justice itself also, blinded as it is with the nature of justice, it still delivers a principle to each and every person. So recently, again, our Prime Minister Modi ji, of course, brought forward this concept of Indianization. It has been adapted very well by some of our courts and judges. Chief Justice Ramanna, for example, recently called about Indianization as the need of the legal system to provide greater access to justice to the poor as the need of the hour. So that is one facet of Indianization that I think has gained a lot of importance. And we also have Justice Nazir, who was kind enough to put forward the entire process and underscore the need to throughout the colonial legal system, as not throughout, adapt, I would say, which is detrimental to national interest, and embrace the great legal traditions as per Manu, Kautilya, Katyanana, Brihaspati, Narada, Parasara, Yajnavalkya, and other legal giants of ancient India. And in fact, that is what the judges have outlined, the future model of our legal system. What should it be, keeping in mind the Indianization and the fact that colonial legal system obviously is a misfit in the current time and hour. And it has been so for some time. So the need to proceed in that direction is something that we need to consider. We have done away. Dr. Mani would have pointed out that we have done away with several laws. We have actually sat as a government. We have outlined, I think, about 1400 odd laws, old laws, which were there, have been repealed. And there has been an entire exercise. I personally have sat through so many of these judicial reforms process, where we have tried to do away with outdated laws. We've tried to do away with old laws. And India, incidentally, is hailed through the world for its adaptability. We have actually modified our laws, and we have been able to do that thanks to the Constitution and the privilege that it has given us to consider everything under the heading of basic structure of the Constitution. So you find that whether it is in the field of commercial laws, whether it is in the field of environment, whether it's in the field of human rights, whether it's in the field of recently, yesterday only we had the judgment on abortion. And I would like to share with you one of the quotes that came around, which is an interesting phenomenon about the Medical Termination of Pregnancy Act and how we transform ourselves into the public good. When the MTP Act was enacted in 1971, it was largely concerning the married women. But as societal norms and mores change, law must also adapt. Changing social mores must be borne in mind while interpreting provisions. Societal realities indicates the need to recognize legally non-traditional family structures. So the ultimate beacon of Indianization, if I might call it, is the larger public good and human dignity, human respect, and that of the need of the non-accessing group of people. While we talk about that, the other Indianization process that we have carried out, which is partly through digitalization, is easy access to the public. COVID times have actually shown us the greatest good in this respect. Even prior to COVID, incidentally, I was also party, and several of us were, to the process of, for example, CCTV cameras. That was for security in the courts. But that was a process of digitalization, which started about 5 years back. And various judgments and the government, in fact, led to this process. Today, we have an even higher access. Recently, the live streaming which started. 3 constitution benches had viewership of about 8 lakh viewers. So you actually have the system being viewed by all from each and every part of the country. What greater process of Indianization could we have? So we're using modern technology for Indianization in the light of the ancient scriptures and in the light of the ancient thoughts, and keeping in mind the public good. So this is the transformation that we have called. Recently, again, we had a judgment and a process set up by the Chief Justice Ramanna, something called the faster system. That scheme itself, example, did what? The Supreme Court, by the click of a button, could send out bail orders to each and every cross-section of society, including prisons, including the prisoners, all starting from several Agra inmates who were unable to get releases because the order itself had not been transformed. So this process that we have been looking at, the have-nots versus the haves, and the have-nots to be looked at with a higher perspective in order to give them greater access to justice in every possible format. We again have transformed ourselves in the process of digitalization in the courts. How we done that? We have several backlogs. People from all over the country did not have access. They had to travel all the way. For example, Supreme Court being the apex body in the country, how to access the higher courts, how to access even the district courts. So the entire process that we've had of e-courts, the entire process that we had of disposal during COVID times has demonstrated that we are able to manage to transform ourselves and thereby give access throughout the country to the 141 crores people who do not today need to move physically in order to get access to justice and can access from various parts of the country. And even after COVID times, most courts have retained one form or the other of digitization so that we can ultimately access justice through that method. We also have the system of e-filing today. We have the virtual court systems. We have e-court portals. There is also, of course, as Dr. Mani said rightly, the process of language, how to have language simplification. That is something that I think needs to be addressed by us as lawyers, as a faculty. Simplification in terms of language, simplification in terms of judgments being rendered. That incidentally is a chapter that I think also needs to be dealt with. We have today judgments of about 500 pages. How do we expect people to really analyze or to understand such judgments which are so lengthy? So I think we need some discourse on this subject to discuss how we can further improve systems so that the common man, the layperson, the poor person can ultimately understand what his rights are, particularly in the era of development of rights. Today, rights are developing every day on a regular basis. This transformation process is an ever evolving one. So we do need to understand how we can get on there. We have e-Seva Kendras, and of course, live streaming has started recently. By the way, that live streaming has a couple of thoughts both ways. There are discussions on whether it is desirable, whether it is not desirable. But all I can say is that today you cannot have people within the court premises in any physical manner, that it would be an impossibility aside from access. So live streaming itself gives that ability to people to access justice from whichever part of the court they come across. One last part that I would like to talk about at this point is public interest litigation. I think the evolution of public interest litigation itself has been a process of Indianization for us. And that again deals with the underprivileged, the disadvantaged, who have ultimately reached the portals of courts to say, we want, what happened ultimately when Chief Justice Bhagwati brought up this concept. Let us see what he said. We cannot allow our judicial thinking to be constricted by reference to the law as it prevails in England, or for that matter, of that in any other foreign country. We no longer need the crutches of a foreign legal order. We are certainly prepared to receive light from whatever source it comes from, but we have to build up our own jurisprudence. And this is when he spoke in the MC Mehta case way back in 1986, when we talked about the public interest litigation system. And I think that itself is an evolution of India in the Indianization process to bring in the disadvantage to the level of the advantage, to bring at par the have-nots to the haves, and allow the entire principles. For example, locus. Professor Chawla, I would just address you on this. We used to have a concept of locus. You can only file a case if you are directly affected. Public interest system is the first time that you actually allowed a large cross-section of people or a cross-section of people to fight for the rights not only of their own rights, but for the rights of others. So, for example, the bonded labor. For example, the jail prisoners. For example, let us say women. We've had major achievements in this direction. And I would just flag it at the last instance to say this. Let us see how the Supreme Court has been, in fact, taking care of this in coordination, I would say, in one way, with the government also. Triple Talaq case. We see that as a complete travesty of justice. But you ultimately had a petition, which was an individual petition. So let us not mix up public interest only with that. But keeping in mind Article 141 of the Constitution, directions were given holding the triple talaq is ultimately unconstitutional, arbitrary, discriminatory, and needs to be quashed at the threshold until an appropriate law is put into place. You ultimately ensure that triple talaq practice, which is abhorrent to human dignity, should not be allowed to prevail. This is the manner in which we have actually seen, and therefore I would say that today we have the entire system of the legislature, the executive, and the judiciary, all the three pillars. I would also flag in the fourth pillar being the media, but that is somewhat on a different platform. The three initial pillars of democracy, which have ensured that not only do we go forward, not only do we transform ourselves into the globalization world and bring ourselves at par in the nation, but at the same time, we again revive our scriptures, our values, our dharma, our duty, our access, our justice, our rule of law, and also issues like the panchayati system. We've had and been able to develop the panchayati system in a very magnificent way and given it constitutional protection in 1992 by the 73rd and the 74th Amendment. And in the same light, we came up with the Lok Adalats. Lok Adalats again was a system where we developed the process of mediation. And again, as we talk, we've been talking about Section 89 of the CPC, which again compels parties to mediate as much as the mediation bill, which Dr. Mani might have told you more about, which is recently pending again to ensure that everybody lands up with a win-win situation. This is one of the biggest examples of Indianization. India has always believed in a system of justice which is not adversarial in nature, but something which is collaborative and something which gives a finality to the system so that you can have justice for all. So with this, I think our efforts at this conclave and the faculty and all of you to put together a new concept in, let us say, an old concept in a new manner or a new concept in an old manner, whichever way we do, whether the glass is full or the glass is empty, that is a consideration, but it is all in the same breath. We are reviving ourselves and we are constantly churning out new energies with collaborative with old energies. And this is the way forward for us. So thank you very much. I look forward to hearing the rest and always to be back in the faculty, Professor Kahlon, at any stage, and Professor Chawla. I look forward to that. Thank you very much.
Thank you so much, ma'am, for your truly inspiring and enlightening words. Now, I would like to invite our chair, Honorable Justice Sunil Ambani, to kindly address our students.
Thank you, Sanjana. We have had the benefit of the erudite speech of Dr. Pinky Anand, very forceful advocate for human rights and women's rights in Supreme Court, and Mr. Rajiv Mani, Dr. Rajiv Mani, Additional Secretary, Department of Legal Affairs, giving us the point of view of the government. Professor Mahavir Singh Kahlon, Dr. Alka Chawla, I'm very thankful to you for inviting me. Apart from being a judge and Chief Justice, I was also a chairman of the E-Committee of the Supreme Court of India for a period of 7 months. Prior to that, I have been from phase 1, implementing the E-Committee program in UP, state of UP, which is the largest state population-wise since 2010. And also the Mediation and Conciliation Committee, as well as the executive chairman of the State Legal Services Authority. My point of view on the Indianization of the Indian judicial system is slightly different. You see, we started with the laws. We are calling them colonial laws. Are they colonial laws? Of course, they were made by Britishers to rule India. But when the Constitution came, Article 372 saved all those laws except for those which are enacted. Now, these are the laws which were saved. Now, we have had 70 years of time to change them. If we wanted to change, we could have changed them. If we are continuing with those 100-year-old IPC and CRPC and Contract Act and Evidence Act and Transfer of Property Act, the choice is ours. But I tell you that whatever laws have been enacted thereafter had drawn inspiration from those ancient laws. Dharma was the rule on which all the laws are based. We have dharma. Dharma is the object, not the regulating the society or governing the society. It is to establish dharma in the society. We have had a lot of efforts of bringing in the new laws getting inspiration from our ancient laws, as well as the principles of Mimamsa. Many times Supreme Court has brought in the principles of Mimamsa in interpreting of the statutes. So we cannot say that we have not Indianized our law. But what is happening is that we are not changing with times. You see, recently you must have noticed almost all the laws are putting the burden of proof in the wrong way. The whole principle of criminal law that you are innocent until proven guilty is being toppled. Now let me come to the how this idea started. Of course, Dr. Mani is absolutely right that this idea was floated by our Prime Minister, Mr. Narendra Modi, from the ramparts of the Red Fort on 15th of August. And his idea, what he said was the laws should be simple and accessible. Simple and accessible. That's what he said. Justice Ramanna perhaps went a little further to explain those concepts, and that is being felt by everybody who has been in the judicial system. I've been in the judicial system for more than 4 decades, almost 45 years. I was advocate on record in Supreme Court, practiced in district court, practiced in high court, and also became judge and then the chief justice, then the E-Court committee chairman. You see, what Justice Ramanna said, very aptly said, that Indianization of judicial system doesn't mean that we bring back the ancient laws of the Chola period and the Gupta period and govern our country accordingly. He said we must understand the Indian ethos in having those laws, and mostly procedural laws, process laws. Now, increasing accessibility by molding the system to suit the needs and sensibility of the Indian population. That's what Justice Ramanna said. Justice Ramanna said it's a very multidimensional concept, access to justice. Inclusivity is the key word. He says providing access to justice is the first principle. Removing the linguistic barriers. Remove the linguistic barriers, you're closer to justice. You understand the process. Then you have reforms in practice and procedure. We have the same CRPC 100-year-old and CPC 100-year-old. We are doing patchworks by amending them, sometimes going forward, sometimes going backwards. It is now the time that we must revise those procedural laws to make them more simple, brief, and human. Now, development of infrastructure. Now, that was the key word Justice Ramanna said, because he was very passionate about development of structure. We said we don't have adequate number of judges. 20% to 30% posts of the subordinate courts are lying vacant at any given point of time, and about 40% in the High Court. By filling up all the vacancies in Supreme Court, you cannot provide justice to the people of the country. You have to fill up vacancies in the High Courts and District Courts also. Imagine the plight of a person who returns back from the court 100 times, either the judge is not there or the lawyers are on strike. What kind of humane system we have given to them? Now, augmenting the strength of judiciary, and then he laid a great emphasis on judicial infrastructure. I tell you, in Allahabad High Court, your sanctioned strength is 186, but the infrastructure is not for even 110. Whenever the Chief Justice of Allahabad High Court said, I want more courtrooms, more judges' residences, more staff, they said, first you fill up the vacancies. The Chief Justice says, it is not in my hand, I'm recommending names. Of course, you should have recommended more. But then, you have to prepare your infrastructure for those eventuality when you have the sanction, even the sanction strength, not to say of increased strength. Now, the topic of today is, how can digitization help in Indianizing the Indian judiciary, or rather, I would say, to make it more effective. Now, what one of our old Chief Justices of India said, that we are running judiciary in the present day by bullock cart methods. He was not wrong. He was absolutely right. By bullock cart methods. We could have seen the loads of files which were being transported to the court, how the prisoners come to the court, hundreds of them, only to mark their assistant, their presence. And Justice Krishna Iyer made it very well. He said, this is a very illustrative example. Each word is important. He says, the judicial process is a riddle wrapped in a mystery inside an enigma. Now, this was said by Churchill for the Russian rulers in Second World War. Mystery inside an enigma. what with its baffling legalese, lottery techniques, habitual somnolencies. A somnolency is a quality or a stage of being drowsy. Extensive proclivities, multi-decade inconsistencies, tyranny of technicalities, and interference with everything with a touch of authoritarian incompetence. Imagine a judge today sitting in civil, tomorrow criminal, third day he's in corporate matters, on the fourth day he's sitting in tax matters. See, that is why the technology had to be brought in. And I'm a first, because I've been there implementing this technology. The committee, I've been there, the head of the committee also. Technology is not to humanize, to Indianize the judiciary. It is to humanize the judiciary. It's to make it transparent. You see, what we say is the sunlight is the best disinfectant. Similarly, technology makes the whole system transparent. Technology can make the system moving less in corruption, people having more trust and confidence in the system when they see from by logging on, where is the case, what is the stage, who's the judge who's going to hear it today, and you don't have to rely upon the lies spoken by his counsel. I've also been a counsel, please pardon me, lies spoken by his counsel. Aaj tumhara case ho jayega, aaj ho jayega. And he knows that it will be adjourned. The litigant knows where his case is, what is the stage. Now, what are the simple methods to Indianize our judicial system, to make it more humane? First, revisit and simplify the substantive laws. That's exactly what the law minister said yesterday in the inaugural session. We have to simplify our laws. Can anybody read the Income Tax Act or the GST Act, or in any way forget about it, the 20 provisos and 6 explanations? You know, it is impossible. Even a lawyer can't read it. Even a judge has to go through it 10 times. So what is that law if it has to be implemented, if it can't be understood? So what law minister said was absolutely correct. We have to simplify the substantive laws, the laws, entire laws. Now what he said that we have done away with laws. We have done away with so many thousands of regulations and notifications. Nothing great about it. This is called, in Europe it is called, England it is called legislative spring cleaning. You have to remove those laws which are absolute obsolete laws. I'll give you an example. A few years